The matter before the court is our docket number JUD 24-1. The matter is before the court for hearing on the sanctions to be imposed on Judge William Blaisdell IV. If counsel and respondent wish to identify themselves by saying their names for the record, starting with the board or the committee.
McArdle III for the main committee on judicial conduct.
William B. Blaisdell IV, representing myself.
Thank you. Given that the allegations are deemed admitted, we are really here on sanction. We'd be happy to hear from you, and I'm sure that various members of the court will have questions as well. Mr. McArdle.
Thank you, Your Honor. Chief Justice Stampo, other members of the court. As I said, I'm John A. McArdle III. I'm counsel for the Committee on Judicial Conduct. Seated at council table is Nancy DeMerchant, who is the current chair of the Committee on Judicial Conduct. Canon 1, Rule 1.1 requires that a judge shall comply with the law and the main code of judicial conduct. Judge Blaisdell's failure to file tax returns, income tax returns for the years 2020, 2021, and 22, his failure to pay child support and attorney's fees when they were owed, the contempt of court finding against him, all demonstrate serious, willful, and repeated violations of Canon 1, Rule 1.1. Canon 2, Rule 2.16a of the Code requires a judge shall cooperate with judicial disciplinary authorities. Judge Blaisdell's failure to respond to the Committee on Judicial Conduct, despite numerous requests to do so, including telephone calls involving my predecessor, Cab Howard, and the judge, in which the judge stated that he had not received the complaint/questions posed to him by the committee, were repeated violations of Rule 2.16a. And I note, as I think I noted in the paperwork filed with the court, that none of the letters sent to Judge Blaisdell with the complaint and the questions were ever returned to the Committee on Judicial Conduct, and therefore we believe that the judge's representation that he never received them was less than candid. Canon 2, Rule 2.16a of the Code requires that a judge shall be candid with judicial disciplinary authorities. I just mentioned the problem with that in terms of Judge Blaisdell's conduct. Although a judge is not acting in an immediate judicial capacity, when he is engaged in conduct like the conduct we're going to talk about in this proceeding, his conduct remains subject to the standards created in the Code of Judicial Conduct. That's what this court said in 2016 in the matter of Robert Nadeau. This court has also said, the code's reach beyond the bench to conduct such that an issue is here is necessary because judges are the face of the judiciary, and their extrajudicial conduct and activities, like their conduct in the judicial role, reflect on the court system. As stated in a leading treatise on judicial ethics, judges are held to higher standards of integrity and ethical conduct than attorneys or other persons not invested with the public trust. This heightened standard of conduct extends beyond the limits of the judge's court, for a judge's duty does not stop at the robing room door. Even in a judge's personal life, he or she must adhere to standards of probity and propriety far higher than those deemed acceptable for others. This court has said that the delivery of justice and public confidence in the integrity of the judiciary necessarily rests on judicial officers' adherence to the ethical standards prescribed by the Code of Judicial Conduct. The IRS code says it's a crime to intentionally fail to file a return or pay tax that is required by the IRS. Likewise, failure to pay main taxes is a crime per 36 MRS 837, Section 5332. There is no excuse for Judge Blaisdell's repeated failure to file tax returns. He's a longstanding practicing attorney, 27 years or more, and a judge, and he knows better. In her contempt order dated March 8, 2024, Judge Worth stated, "The court on September 14, 2023 found that defendant's annual personal income is about $326,000. I think this is an important fact because Judge Blaisdell says that despite his conduct, he was able to conduct his law practice without issue and to basically do his judging without issue. But what Judge Blaisdell did do was he unjustly punished his children and his ex-wife by withholding money due to them due to his anger and spite. And he made his ex-wife and children suffer. And a judge should not do that. Nobody should do that, but a judge certainly should not do that. He knew what he was doing. He tries to excuse his conduct as a matter of being due to depression. But failing to file tax returns for 3 years is a matter of intent, particularly if you're able to undertake your private law practice, handle your clients, handle your cases, and handle your judging. So we maintain that Judge Blaisdell meant to withhold money from his family intentionally and that he punished them unjustly. Judge Blaisdell failed to cooperate with the Committee on Judicial Conduct. As I stated minutes ago, the committee reached out to him several times by mail and by phone, and he asserted that he had not received the complaint with the questions asked of him for consideration by the committee. Because Judge Blaisdell had an active law practice and made a good living during the years when he failed to pay his taxes and withheld the money from his family, it can only be concluded that he chose his wrongful behavior. Unfortunately, Judge Blaisdell placed himself above the law when he failed to meet the legal obligations to his family, failed to comply with the court order regarding monies owed to his family, and he failed to cooperate with the Committee on Judicial Conduct. He placed himself above the law. In the last decade, there has been an erosion of public trust and confidence in various governmental institutions, the rule of law, and in the judicial process, including, unfortunately, the United States Supreme Court. Unfortunately, now many people believe that those in positions of authority and power live by different rules and are above the law or are not held fully accountable for their actions. The law court has said in 1981, any sanction must be designed to preserve the integrity and independence of the judiciary and to restore and reaffirm the public confidence in the administration of justice. The Committee on Judicial Conduct is composed of judges, attorneys, and public members. The committee evaluates dozens of complaints against judges each year. Decisions of the committee, therefore, are a product of the collective wisdom of judges, lawyers, and non-judge, non-lawyer citizens, like the chair of the committee, who sits in the court today. As a result, the members of the committee bring various life experiences and perspectives to address what sanction is appropriate for the misconduct of Judge Blaisdell. In bringing that collective wisdom to bear, the committee has recommended that Judge Blaisdell be stripped of his judgeship. I think it's important for the court to note that when people of divergent backgrounds and roles in life are confronted with conduct that so blatantly shows contempt for the rule of law, and that the conduct is serious enough, that the sanction need to be unequivocal and strong. Although this court is not bound by the recommendation of the CJC, we respectfully suggest that the court follow our suggestion as a guidepost for the issuance of sanctions against Judge Blaisdell. And more specifically, we believe that given Judge Blaisdell's violation of Maine and federal law, his failure to obey court orders, and the finding of contempt against him, his repeated failure to cooperate with the Committee on Judicial Conduct, all undermine the public confidence and the integrity of this judiciary. Therefore, we recommend that Judge Blaisdell be reported to the legislature and removed from his judicial office.
Mr. McArdle, let me follow up on that. We don't have the power to remove Judge Blaisdell ourselves. You agree with that?
I do.
And that the process for removal is either by impeachment or address of both branches of the legislature to the executive pursuant to the Constitution, right?
Agreed.
So if we make that referral, there's no certainty that any action at all will be taken.
Well, action will be taken of one type or another. It may not be what the committee would like to see happen, but yes, Your Honor, there could be an ultimate decision that this conduct is allowable without sanction.
Okay? Or doesn't warrant removal. If we made the recommendation, I mean, these other bodies could determine, hey, it sounds pretty bad, but we don't think it warrants removal by impeachment or address of both
Sure,
branches.
a lesser sanction or a finding.
And then wouldn't we be in the position of having imposed no sanction at all?
Yes.
And is that what the committee is asking?
No, but the committee has confidence in the legislature and that the fact that the conduct of Judge Blaisdell rises to that where a sanction will issue no matter who issues it.
Can we impose a sanction in addition to referral?
Well, that's a good question, Your Honor, and I don't know the answer to that. I'm not familiar with any Maine case that has done that.
Are you familiar with any case where the committee or a similar body has asked this court to recommend removal?
Well, not really, because the closest case that I can think of is in the matter of Cox, and this is a bit of a memory stretch, but I think what happened there was the judge ended up resigning before he could be stripped of his judgeship. Nonetheless, even when a judge resigns voluntarily, it is advisable for the sanction process to continue as a matter of public interest and upholding the integrity of the court. But to go back to your question directly, no.
Has any of the actions in this case, so far as you're aware, had direct effect upon litigants or the judicial system writ large, other than what you indicated, which is obviously there's an obligation to comply with the law and to cooperate with the committee? But beyond that, has there been impact on his actions as a judge? So far as you know.
In terms of my knowledge, I'm going to say no, but qualify it. For purposes of my position and the confidentiality of the Committee on Judicial Conduct, I don't think I can say much more on the topic.
Okay.
And maybe there'll be more information one way or the other in the future.
Okay.
Is one of the things that, in terms of determining what course of action this body takes, is one of the things that would be appropriate for this court to take into account as would be what the judge did in order to finally respond to the deficiencies that were pointed out and his violations of the Code of Conduct? Such as? filing and paying the back taxes, such as dealing with the contempt by paying the amounts that the court deemed to be owed. How should we factor that into our determination?
My suggestion in that regard is that, although those are steps in the right direction, and that various limits have been put on the judge in monitoring with respect to his private practice of law by the Maine Board of Bar Overseers, that sanctions against him as an attorney practicing law are one thing, but sanctions against him as a sitting judge are another thing. And as I mentioned earlier, quoting this court, the judge is held to a different standard than an ordinary attorney or anybody else. So I think it's fair for the court to consider what the judge has done in the face of his conduct, and his conduct being known, and his conduct being publicized on TV and on the internet and in the print media. And I think countervailing those factors are the public interest in seeing that this court actually does something with respect to discipline against the judge for the reasons that I stated earlier. Maine has a great judiciary. It has a great history of judges and integrity to them. And I think that all things should be considered. But I urge that at the end of the day, in this particular case, when you're talking about breaking the law and contempt of court and repeated conduct and failure to cooperate with judicial disciplinary authorities, strike 4, you're out. That's my suggestion.
Has the Board of Overseers concluded, you referred to the sanctions, has the Board of Overseers concluded proceedings with regard to Mr. Blaisdell?
I believe they have, and they've issued a number of conditions upon him,
Okay.
which I'm sure he'll bring to the court's attention.
Any other questions from anybody? There don't appear to be.
Thank you.
Thank you, Mr. McArdle. Mr. Blaisdell?
Chief Judge, members of the court, I am here asking that you not remove me from office of Hancock County Probate Judge and instead issue some other sanction against me. I understand I take full responsibility for my actions and fully submit to this court. I've been a probate judge for Hancock County for almost 10 years. I've been elected by the fine citizens of Hancock County in 3 elections. I've enjoyed representing the citizens of Hancock County these 9+ years, and have taken great pride in ensuring that everyone who comes before the court is treated with respect and that their voices are heard. Even though individuals have respectfully disagreed with my decisions, I believe that they respected the decisions and understood why I made those decisions. In the 9+ years that I've been fortunate enough to sit on the bench, I have had very few decisions appealed and even fewer overturned. I have very few complaints filed against me with the Judicial Committee. I understand that I've let my personal life with my ex-wife interfere with my duty to the court. I take full responsibility for that, and I am diligently working to ensure that the matters involving my divorce and my children are in full compliance with all court orders and laws. I understand that my personal divorce case has played out in the media due to unfortunate circumstances.
What do you mean unfortunate circumstances?
Individuals leaked it even before I had the decision from the court regarding the contempt motion. And I take responsibility for that, for those actions, and I paid all past due child support, and I would just like it noted for the record that the decision against me back in September was for past due child support. It wasn't for current ongoing child support. That was continued to be paid. Furthermore, even though I had that obligation, I still had my children 50% of the time. I don't want this court to think my children were suffering. Granted, I did owe that back support and was trying to make arrangements to have that paid, as well as the back attorney's fees and things of that nature. So it wasn't for, child support was continuing to be paid. It was that back child support that was the issue. I have also, to rectify the situation, cut back on the number of cases I am accepting to have a manageable caseload and to fulfill all my obligations. Like many attorneys who do court-appointed work and accept court-appointed cases, I had become overwhelmed with the number of cases I had, often feeling pressured to take cases due to the lack of available counsel. And I didn't seek out the additional help in dealing with the additional workload. During this time, I also let my mental health deteriorate, which further negatively affected by not being able to get my medication that I was supposed to be on due to issues between my doctor's office and the pharmacy. I have since rectified that by setting up a plan with my doctor's office to ensure that if I have problems, there's a number and a person I can contact directly who will see to it that that is taken care of. I have also been attending weekly counseling since March to deal with issues surrounding the divorce case, as well as the anxiety and stress that have come with being a judge and an attorney. I am also involved with the MAP program through the main assistance programs for lawyers and judges, and have found it to be quite useful in dealing with issues surrounding stress and anxiety. Furthermore, I have come to an agreement with the Board of Bar of Overseers, which unfortunately is still not finalized to the end of next month. I have certain conditions which I must abide by, and those conditions include continuing counseling, making sure I have my medications, signing releases so that they can talk, participation in the MAP program, and that I will abide by any and all conditions that they further seek. I have made mistakes, and I take full ownership of them. I didn't request a hearing on those specifics. I humbly and respectfully ask this court to continue to allow me the fine citizens of Hancock County as their probate judge, and I ensure that I will follow all and any recommendations that this court sets out.
When is your term as judge up?
2 years.
So in November, 2 years, or
Well, January.
January?
The election's in November, but
Right.
I would serve till December 31st.
So 2.5 years from now, or 1.5?
2026, December of 2026.
Thank you.
What does it mean to you to take full responsibility? You said that several times. What do you mean by that?
I admit that I was in contempt of court due to unforeseeable, I take full responsibility.
Due to unforeseeable?
Excuse me?
Did you say due to unforeseeable?
No, there was an issue. I was prepared to go to court that day. I understood it to be at 2 o'clock. It was at 8:30. I had, unfortunately, 2 DHS C1 hearings that morning, as well as I was attorney of the day for the in custodies, which I had to handle. After I got done with my DHS cases, I thought the matter was at 2 o'clock that afternoon instead of 8:30. And that's my own fault, which I take full responsibility for. I did head down there and attempt to deal with the issue. I called the attorney involved, indicating I had the checks necessary
Okay.
for the back child support, the back attorney's fees, things of that nature, and interest. Unfortunately, by that point, he said, what's done is done, and I went on from there.
Can I just be clear about this? When was the contempt hearing?
March 8th, or it was March 6th, 7th, or 8th, somewhere around there.
And you were prepared to go to court with the checks to pay the entire balance
Correct,
owed?
correct.
Did
And I
you-
have,
Did you seek any, I mean, you didn't show up, you knew you had a hearing that day, you knew you missed
I-
it. Did you take any steps after that to bring to the attention to the court that you inadvertently failed to appear and that you were prepared to make full payment?
I was down there, I did go down there, and I went down what I thought was early, because I had to do in-custody arraignments by video for the people in the Hancock County Jail as lawyer of the day. So I was down there around 12 o'clock, and I sat in the conference room, did them by video, whatever. And then when 2 o'clock came and I got done with the in-custodies, I went to the clerk's window, asked, where is everyone? And they're like, no, it was at 8:30. So I informed the clerk, whatever, and then I immediately contact my ex-wife's attorney saying, look, I'm here, I have the checks, let's settle this. And that's when it was said, what's done is
So
done.
doesn't that beg the question about why, if you had the checks and the means to pay it at that time, it wasn't paid before then?
I was getting the money together because it was a substantial sum. It was close to $50,000. And I had to get assets sold and things of that nature. But I did make payment in full shortly thereafter, even though the
understand.
contempt was issued.
I understand that. It was an amount that had accrued over a period of time, so I'm questioning. I understand your explanation as to, and taking responsibility for missing the hearing, but it doesn't really explain why the payment wasn't, if you had the means to make the payment that day, why it wasn't paid before that.
It took me time, to get that money together to go ahead.
Why didn't you go to the contempt hearing?
I thought it was at 8:30, and I had 2 matters pending in the district court in
I
Ellsworth.
thought you said you thought it was in the afternoon.
Right, at 2 o'clock. But I had 2 matters pending in Ellsworth District Court. This happened in Waldo County, was the contempt motion. So I attended those and then went down there for what I thought was a 2 o'clock hearing.
Just to follow up on Justice Douglas's question, to the extent that you found out that you were there at the wrong time, the proceeding had gone forward, you had the money to pay up the amounts that the court said that you owed, why wasn't there a motion, once the contempt order issued, actually I would think before, but once the contempt order issued, why wasn't there a motion for reconsideration explaining the circumstances to why you weren't there and that you were in fact ready to pay the amounts that were owed?
In hindsight, I wish I would have done that, but I was going through mental health issues at the time, so.
When did you actually make the payment, deliver the checks?
I don't have that exact date. I believe it was 2 weeks later.
So you held them, you had them made out that day, and you held them for 2 weeks. Why didn't you respond to the committee's inquiries?
I did not receive the initial. I did receive the ones that were sent to the probate court. And granted, I didn't respond as I should. The last one that I should have responded to, which I intended to, was the one that gave me 21 days from the February date to respond, and that's when I went into a mental health crisis.
Did you file your federal or state tax returns for 2020? Have they now been filed?
I have sent in money. I haven't, I'm waiting on the documentation. I still have to file.
I
I've
take that's
sent
a
in
no,
money.
then.
That's correct, Your Honor.
And have you filed for 2021 or 22?
No, Your Honor, and that's why my income, what was projected as my income is way over what I actually make. And that's why it was such a hardship to come up with that, but I am current on all my child support obligations.
So do I understand that you've actually paid money to the IRS and to the state of
revenue,
Maine, but you
correct.
haven't filed
Correct.
the
I
actual
haven't
form?
official filed the documents, that's correct.
one of the other parts was not just the failure to make payment of the district court orders, but also the failure to file the required financial documents.
Correct,
And you were sanctioned for that as well.
correct.
And do you want to address that, why you didn't do that?
Well, I have paid the, what I was sanctioned for, the attorney's fees and things of that nature, so.
Yes, my question is why you didn't file the documents or produce the documents.
The tax returns?
The allegation is that you failed to file required financial documents in the divorce proceedings and were sanctioned for that. My
Right,
question
and
to you.
it relates to the tax returns, Your Honor.
Okay. Did you file anything saying, I haven't filed them, and so therefore I can't
I-
produce them?
I have verbally with the court, I have stated that.
Okay.
You asked not to be removed from your position as probate court judge. You heard the presentation that was made on behalf of the committee. Do you think that any sanction is appropriate, and if so, what?
Censure, I do think sanctions are appropriate. I did disregard, I fully admit that and take full responsibility. Censure would give me time to file those returns, and I will be up to date, and I will ensure any other requirements of this court, I will follow to the letter.
I'm still not clear why you haven't actually filed the returns. You don't need to send money in, do you? You haven't, have you taken any steps with respect to
I have. I'm getting
those past returns on the IRS?
Yes, I'm getting the documentation, the sales of stock, things of that nature, which is what's holding it up.
You said you're in some weekly counseling?
Yes.
What kind of counselor are you seeing?
Just a general counselor. Her name's Carolyn Parker. She's out of Bangor. Luckily, I'm able to see her on the weekends because of my schedule. She's helping me with the divorce, with the anxiety, the depression, the stress, just talking about how things are, how things have happened in the past, and what has happened. So,
When did you start seeing her?
March of this past year, shortly after the contempt motion.
You referred to not being able to get some medication. Had you been already diagnosed with any mental health,
Yeah, I'm diagnosed with depression, anxiety,
but had not been in treatment other than potentially medication?
just medication, yes, Your
Okay.
Honor.
Any other questions from any members of the court? Anything else you wish to say?
No, Your Honor.
All right, thank you.
Thank you.
If I could
You can?
briefly.
You may.
I wasn't planning on talking about this particular aspect of things more than I did, but since the court raised the question about payment of the financial obligations that were owed by the judge, Judge Worth, in her contempt order, noted, among other things, on page 4, that in 2023, Judge Blaisdell purchased a vehicle for about $77,000, and that besides that, he owned an SUV and a BMW convertible. Obviously, the court will draw its own conclusions about the judge's explanation for when he paid the obligation or what he had to do in order to pay the obligation. I think the fair inference from the judge's testimony is that he chose not to meet the obligation and could have made arrangements to meet the obligation much earlier. Part of what he did to meet the obligation, according to his own statement to the court, is sell some stocks. Certainly, he could have done that on an earlier date, and he probably could have sold more stocks on an earlier date as well. I appreciate to some extent Judge Blaisdell suggesting that some sanction be available or issued to him, but the reality of it is this. In his written submission, he asks for a suspended suspension, which really is saying, don't do anything to me at all. And now he is saying, well, how about a censure? I don't think he perhaps fully appreciates yet what he failed to do and what he did that was wrong. The reality of things is that even if Judge Blaisdell is no longer a judge, he's an attorney. He can make a living being an attorney. He can practice law full-time. He can make a good living. He can focus on his health. He can focus on his family. And what will be missing from his life is being a probate judge. And I want this panel to understand that we're not seeking to take away the judge's life, but what we're seeking is accountability for very serious violations and a restoration of public trust in the judiciary to the extent that it's been compromised and publicized. And therefore, we strongly urge that steps be taken for the judge's removal. Thank you.
Is there anything that he's not doing now that you think he should be doing?
Other than tendering his resignation, no.
And to the extent that you suggest with regard to your assertion about the purchase of the motor vehicle, there may be some credibility problems with regard to representations by the judge. Do you have those same concerns about his assertions of mental health issues?
Let me make sure I understand the question. Are you asking whether I am in any way challenging his assertions about statements he made concerning his mental health?
Yes.
No, but I will make one comment on that, because when the judge said that the only treatment that he had received before the contempt order was the taking of medication, and this is an assumption, but I think it's a fair assumption that whoever was prescribing medication had some conversation with him about the need for that medication. And in my experience of practicing medical negligence cases for 35 years, practitioners that speak with patients about mental health issues and issue a prescription for medication also suggest, if it hasn't occurred to the patient already, that they get counseling and other help besides pure medical management. That's all I have. Any more questions?
Thank you.
Thank you.
Anything further, Judge Blaisdell?
Just briefly, just to clarify the issues regarding any cars. The car was purchased before this even contempt motion or even before it occurred. It was a replacement SUV for the SUV I have, which was a 2008 Nissan Armada that was basically falling apart and unsafe for me to drive the kids in. Well, I still have it. It's not viable use. As far as the BMW that I do have, it's a 2003 BMW, 20-something years old, that was purchased for $6,000 before the divorce was even gone through. So I tend to hold on to things. I'm not misrepresenting anything to this court.
The judge's contempt order, though, specifically notes as well that in September of 2023, it had found that your personal income was about $326,000 a year. You're now suggesting, or you didn't say it explicitly, but implicitly, I think that maybe that was more than it really was.
Way more than it really is.
Did you move to amend that judgment or anything like that?
No, because I haven't done the tax returns yet, which would be based on, but I assure you it's not, it's under half of that.
Okay,
But
so that was a
nevertheless-
judicial finding, so you knew going into the contempt that there was a judicial finding that that's what your income was.
Correct.
The court also refers to an email that you had about $40,000 in your possession to satisfy your obligations as of December 23.
But it was when it was originally supposed to be resolved, but for a snow day.
Okay, but if you had $40,000 in your possession as of December 23, why was it still unpaid in March?
Because I had other bills that had to be paid.
Okay.
You didn't know how much was due at that point?
I had a rough idea, yes.
Why didn't you pay that amount out of the 40?
Well, in retrospect, I should have.
I mean, that's sort of basic law from this court, is that one can be held in for contempt if you did not pay what you could afford, even if it wasn't the whole amount. You know that.
I do.
Okay. All right.
Well, I do have one other question.
Yes.
And that is, you suggested that you thought that censure would be an appropriate sanction in this circumstance. And I guess the way I want to phrase the question is, do you think that I understand that would be your preference, but in light of the concerns that have been raised to the court with regard to the message that gets sent to the public as to how the members of the judiciary go about their personal affairs while they're handing out judgments, literally, to the average citizen, do you think that's adequate? Censure? Does that address the problem?
I think it sends a message that people make mistakes, and judges are not infallible, they're humans, and that I've taken responsibility for my actions, and that people are given second chances.
The burden of the suspension would fall on other probate judges if it was put into effect, wouldn't it?
It would.
People would have to come to Hancock County and handle your work.
Correct. We often handle each other's work due to various things.
How many days a week do you sit?
One.
1 day a week?
Yeah, but it often entails just more than 1 day. There are emergency hearings and things of that nature.
So on average, how many days a week?
About a day and a half.
Thank you.
Oh, one last question. What's the pay for a probate court judge?
Well, each county is, it varies.
For
Unfortunately,
your county.
$30,000 a year.
Anything else for anybody? All right, thank
Thank you.
you. We will obviously issue our decision in due course. We'll issue it in writing as well. And with that, the court will be in recess.
All right.